Hello friends, welcome to Patashala. In this video, we will learn about the Insolvency and Bankruptcy Code of India. Please do subscribe to Patashala. Also click the bell icon so that you will get a notification every time I post a new video. Back to the topic, Insolvency and Bankruptcy Code. What is insolvency? Insolvency is a position or state in which a person or a company is unable to pay back the loans. If a person is in that state of insolvency, then he or she is called an insolvent person. If it is a company, then it is called an insolvent organization. The state of insolvency can come from poor cash management and when there is a reduced inflow in the cash and also there is an increase in expenses. Differences between insolvency and bankruptcy. Insolvency and bankruptcy are two different things but similar things. They are differentiated by legal proceedings which show that the individual or company a way to repay their creditors. Bankruptcy is the legal declaration of insolvency. By this we understand that insolvency is a financial condition and bankruptcy is a legal position. We also have to remember that all insolvents need not end up in bankruptcy. Journey of the Insolvency and Bankruptcy Code. The central government introduced the code to resolve the arguments that involve insolvent companies. The motive of this Insolvency and Bankruptcy Code is to handle the problem of bad loans that is affecting the Indian banking system. Since the time of its introduction, the Insolvency and Bankruptcy Code has succeeded in a big way by preventing corporates from defaulting on their loans. A number of major cases have been solved during that time. To fix the issues with the insolvency regime, the government had set up a high-level bankruptcy law reform committee in August 2014 under T.K. Vishwanathan. This committee had submitted its report in November 2015 while suggesting new institutions and structures to update the outdated system. After consultations about the committee recommendations, the government prepared a draft bill and introduced it in the parliament. The Insolvency and Bankruptcy Bill was introduced as a money bill in the Lok Sabha in 2015. In case of money bills, the Rajya Sabha can only make recommendations that are not binding on the Lok Sabha. The President has no power to return a money bill. We will learn more about the money bills in the future. The Insolvency and Bankruptcy Code was passed on 11th May 2016. Amendment to the Insolvency and Bankruptcy Code 2016. The Insolvency and Bankruptcy Code amendment was done in 2019 and the amendment bill was introduced in Rajya Sabha by the Finance Minister Nirmala Sitharaman on July 24, 2019. The bill amends Insolvency and Bankruptcy Code 2016. Under the code, the financial creditor, that means who gave the money, may file an application before the National Company Law Tribunal for initiating the insolvency process. The code states that the insolvency resolution process must be completed within 180 days. This is extendable by a period of up to 90 days. The bill also adds that the resolution process must be completed within a total of 330 days. Latest changes to the Insolvency and Bankruptcy Code. Parliament on March 12, 2020 passed amendments to the insolvency law that will help guarantee successful bidders of insolvent companies from the risk of criminal proceedings for offences committed by previous promoters. The Insolvency and Bankruptcy Code Amendment Bill 2020 was passed by voice vote in Rajya Sabha. It was approved by Lok Sabha on March 6th. What was the situation before the Insolvency and Bankruptcy Code? Before the introduction of the Insolvency and Bankruptcy Code, our system had many different laws that are related to solve the problems of insolvency and bankruptcy. All these together, they gave inadequate and ineffectual results, and also there were long delays in the solving process. Some of these include: for security enforcement, there was an act called Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act. For debt recovery by banks and financial institutions, there was an act called Banks and Financial Institutions Act 1993. And for the liquidation and winding up of the company, there was a Companies Act. When all these acts are working together, sometimes a situation arises like when two laws face conflict between each other. And also implementing all these together was a time consuming process. This made way for the formation of the Bankruptcy Law Reform Committee draft and also to introduce the Insolvency and Bankruptcy Law Bill. Because of the absence of insolvency and bankruptcy code previously, creditors have to suffer in many cases. Creditors importantly include the banks. One such example is the Kingfisher Airlines case. But this insolvency and bankruptcy code tries to create a unified framework to resolve all the cases involving bankruptcy and insolvency in India. Need for Insolvency and Bankruptcy Code. This new Insolvency and Bankruptcy Code is the unified framework to handle the issues of the insolvency and bankruptcy in India. This code sets to replace the Presidency Towns Insolvency Act 1909 and the Provincial Insolvency Act 1920. Previously, when dealing with the cases of insolvency, four different organizations used to handle the cases, which include High Courts, the Company Law Board, the Board for Industrial and Financial Reconstruction, and the Debt Recovery Tribunal. When all these four organizations work on a single case, the situation of overlapping authority comes up. When such a situation happens, the process will get complex and also resolution gets delayed. To address this issue, a uniform code is needed to solve the problem of insolvency. That is when this insolvency and bankruptcy code comes into the picture. Insolvency process. Under the Insolvency Code, a financial creditor may file an application before the National Company Law Tribunal for initiating the insolvency resolution process. This National Company Law Tribunal must find that there is a default within 14 days. That means the tribunal must check the credibility of the application filed. After that, the tribunal will constitute a committee of creditors for taking decisions regarding the insolvency process. This committee consists of financial creditors. There are two options for the committee of creditors to decide. It may include whether to restructure the debtor's debt by preparing a resolution plan or by liquidating the debtor's assets. For presenting a resolution plan, the committee of creditors will appoint a resolution professional. When the resolution professional submits a plan, two things might happen. One is the plan gets approved. When the plan is approved, the resolution process must be completed within 180 days, and this period may be extended up to 90 days if the extension is approved by the National Company Law Tribunal. And the second thing that might happen is that the plan gets rejected. When the plan is rejected by the committee of creditors, the debtor will go into liquidation. Resolution time for insolvency. About 60,000 bankruptcy cases are pending in the Indian courts. As per the World Bank data, as of 2015, the insolvency resolution in India took 4.3 years on an average. This is high when compared to other countries such as the United Kingdom, which has an average of 1 year, and the United States of America, which has an average of 1.5 years. The new Insolvency and Bankruptcy Code tries to cut this time of solving the cases to 1 year. The new code attempts to help banks and other creditors from recovering their loans from the bankrupt companies in a timely and efficient way. What more can be done? To solve more cases, there is a need for setting more tribunals in different parts of the country. Bringing the code forward for implementation is just the beginning. This bankruptcy code will make it easier for the companies to put in order the failed businesses. The code creates an insolvency and bankruptcy fund. However, it does not mention the way in which the fund will be used. There is a need for giving out more details about the fund to prevent confusion and to maintain transparency. The pillars of the Insolvency and Bankruptcy Code includes insolvency professionals, information utilities, strengthened adjudication mechanism, and a regulator. For better results, the government will have to make sure that these pillars are institutionalized, which also means they should be made a part of social system or an organization. Maintaining the data is also one of the most important tasks. To do so and to prevent any kind of data loss and also to maintain confidentiality, there is a need to strengthen the technological infrastructure. Though the officials appointed for the purpose of solving a bankruptcy case are well educated, there is a need that they should get some uniform training and ethics regarding the process so that it makes everyone who are working on the case move in a uniform direction and follow the morals. In India right now the situation is giving more importance to the recovery of non performing assets. This might affect the banking system in a negative way. When the bankruptcy case comes before the National Company Law Tribunal, there is a more chance that the banks are going to get very less in return than what they have invested. So, when solving an insolvency case, the situation of banks should also be remembered, and necessary action is to be taken to save the banking system. When the banking system fails, the public will lose their trust in the banks, which is very bad for the whole economy of the country. Here we end this topic. I hope you learned something. Let me know your opinions, suggestions, and questions in the comment section. Thank you. Have a great time.